Hello, Martin Lang here. Welcome to our CIF webinar on the COVID-19 contractors considerations issue. We brought together a team of experts in the various aspects of how this is having and may have in the future, the effect it may have on our industry. We've looked at it from a perspective of contractual obligations, human resources, industrial relations, together with health and safety considerations. Our chairman of the Procurement, Tendering and Contractual Matters Committee, Philip Crampton, will now give an introduction to the format of a webinar. Thank you.
As the coronavirus COVID-19 continues to impact on our industry, the following presentations look at possible contractual remedies that may be available to members as a result of the disruption on sites. We will also be looking at these impacts already taking effect in terms of our staff both on-site and off-site. You will appreciate that we are in unprecedented and a rapidly changing environment. The Federation is issuing updates on a regular basis, and I suggest you visit the CIF website for the latest information. Should you have queries on any tendering or contractual matter, contact our Dublin, Cork or Galway's offices directly. Our first presenter is Siobhan Kenny from Eugene F. Collins Solicitors. Siobhan will set out in detail the contractual position in public or private sector. Members may find themselves in as a result of the risks that the COVID-19 outbreak presents. Our second presenter is Jean Winters, CIF Director of HR and IR. Jean will examine the current guidance from government and give a practical guide around how this affects members and the steps that members should adopt to ensure compliance. Finally, Tom Parran, our Director General, will give an overview on how best to proceed in the circumstances that have been brought about by the COVID-19 emergency. Thank you.
Good morning, everyone. I've been invited today by the CIF to offer some comment and some analysis with regard to contractual provisions and the impact of COVID-19 on construction contracts. As we're all too aware, the circumstances in which we now find ourselves are completely unprecedented, and we, like every society in the world, is facing into possibly weeks or months of uncertainty. There are no easy answers in the contracts, and as you will undoubtedly appreciate, in such unprecedented circumstances and uncharted waters, the standard forms of contract governing most of the construction contracts in the country today do not make specific provision for this particular crisis. A note of caution: going forward, this crisis is not unforeseen. This crisis is very much in the here and in the now. So any contract you enter into from here on in should make provision for these particular circumstances. Turning now to what I'm here to do. As I say, I've been asked by the CIF to come and consider some of the relevant contractual provisions in the common forms of standard contract. In the context of construction projects, the government directives, the current government directives with regard to social distancing, possibly on the cards as coming with regard to social isolation, not to mention difficulties with supply chain, are already causing issues on construction sites and are already impacting on the progress of the works. None of the standard forms of contract deal with this particular set of circumstances, but there are relevant provisions. There are elements of these contracts which may be of some assistance going forward in managing your relationships with your employers, with subcontractors and with suppliers. For this review, we focused on the two forms of contract which are most commonly used on building projects in Ireland, being the RIAI standard form of contract, the blue form, and the PwC employer design contract. And again, for the purposes of the review, I decided to concentrate on three different areas. The first of these are the express or implied obligations with regard to cooperation and engagement, which we will find in each of the two forms we're talking about. Secondly, the provisions of those contracts dealing with delays and how they are to be dealt with and managed. Linked with that are the provisions of the contracts dealing with suspension. The third aspect are the concepts of force majeure, frustration, and ultimately decisions which may have to be made to terminate contractual relationships and the basis on which those decisions can be made. Turning first to the concept of cooperation and collaboration. If ever there was a need for cooperation, this is it. Thankfully, each of the two forms of contract in their own way deal with contractual obligations with regard to cooperation and collaboration. It is important at this time that the parties to construction contracts at whatever level cooperate with each other, engage with each other, and formulate a plan to get over the immediate issues, and possibly try and formulate a plan as to how matters will stand between them once this current crisis has passed. In the PwC contract, I would direct you to clause 4, section 4 of the document. Section 4 of the document deals with all of the administrative functions. It deals with how the parties are to engage with each other and how information is to flow between them. I would direct you in particular to clause 4.1, which deals with the obligations of the parties to cooperate with each other, and very specifically to clause 4.1.3. I'm going to read that clause to you. 4.1.3 sets out that either party or the ER may request clarifications, consultations, workshops, exchange of information and expertise or investigations, although not provided for elsewhere in the contract. The request shall specify purposes and, as relevant, proposed participants, arrangements, methods, and any proposals for recording or agreeing results. That is the means whereby the parties to this form of contract can actually engage with each other or compel each other to engage. And it's a very important clause in the context of this crisis. Clause 4.1.1 contains the general obligation on each of the parties to cooperate with each other and support reciprocal cooperation for contract purposes. Under the RIAI form, the obligation to cooperate is not so clear, it's not so transparent. The obligation arises from an implied obligation. I'm sure many of you will be familiar with the principle that it is a breach of contract for either party to actively prevent the other from complying with its contractual obligations. That's known as the doctrine of prevention, the prevention principle, and is relied on regularly in construction disputes. The corollary of the prevention principle is the positive principle, the positive duty to cooperate with each other for the purposes of facilitating the ready progress of the works. There's recent case law to the effect that a failure to comply with an obligation to cooperate can amount to a fundamental breach of contract. So you can take it that the obligation to cooperate with each other is enshrined in both of these forms of contract and is, to put it mildly, a useful tool in this present climate. Have you engaged with the employer? Have you reached out to your subcontractors and to your suppliers to ascertain the difficulties that they are facing and any proposals they might have in order to get over this present issue and be in a position to progress and bring the works forward once the present constraints disappear? The next issue on my list is the issue of delay and how delay is managed in construction, in the two forms of contract that we're discussing today. All issues in relation to time are dealt with under Section 9 of the PwC contract. And Section 9 is very specific about the contractor's obligations to progress the works, the contractor's obligations to be diligent in facilitating and progressing those works, and in engaging in the project. Clause 9 is also the clause where you will find the date upon which the site should be made available, the date for completion, the provision with regard to liquidated sustained damages, and the provisions with regard to extensions of time, and your ability to apply for an extension of time should circumstances allow you to do so. Clearly, if an extension of time is available to you, then it should be applied for. One of the purposes of an extension of time is to provide protection against liquidated and ascertained damages. Clause 9.3 is the very significant and relevant clause when dealing with delay under the PwC contract, and it is quite demanding. If you are to seek an entitlement to an extension of the time available to you to complete the contract works, then you must do so in accordance with clause 9.3 and possibly with clause 10.3 as well. Probably prudent to serve notices under both of these clauses when serving them. Clause 9.3 requires that as soon as you become aware of a factor which might delay the works or impact on the time available to carry out the works, then you need to notify the ER of that fact. Have you done so? Within 40 days of that notification, you are furthermore required to provide detailed information, a detailed analysis of the event and its likely impact on the progress of the works. It's important with all of these deadlines, with all of these notices, that the second or follow-up notice is also provided. A failure to do that might result in a loss of an otherwise valid entitlement. So therefore, careful attention to the notice periods and the follow-up notices which require to be served should be paid. Clause 10.3 is also clearly of significance, and you will be aware that clause 10.3 is the clause which provides that if you become aware or consider that under the contract there should be an extension of time or an adjustment to the contract sum, then you are required to provide notice of that issue to the employer's representative within 20 days of becoming aware of that issue. Within a further 20 days from the date of the initial notice, you are required to provide a follow-up notice in which you set out details of the issue, details of its impact on the works, and details of its likely impact on the contract sum. As I've just said, adherence not only to the notice requirement, but also to the requirement to provide the follow-on notice is extremely important. These notice requirements are condition precedent. A failure to comply with a condition precedent will or may result in a loss of entitlement altogether. If a claim is submitted, clause 10.5 deals with the employer's representative's obligations with regard to that claim. And clause 10.5 says that the employer's representative has a couple of things that he can do. He can respond immediately and reject your claim. He can seek further information, or he can determine the claim. He can make a decision that your claim is valid and should therefore be paid, or the extension that you're looking for be granted. Clause 10.5.3 sets out that if the employer's representative has done none of those things within 20 days of the date of your submission, then he is deemed to have rejected it. Again, this is an important clause to bear in mind when everything is upside down and topsy-turvy. It would be very easy to lose sight of important deadlines, to lose sight of cut-off points for the making of claims. If that 20-day period elapses from the date on which you submit your claim, then under this contract, the employer's representative is deemed to have rejected your claim outright, and from the date of deemed rejection, you have a period of 28 days within which you can take your claim further. And by taking your claim further, that means that the claim is referred on to conciliation. That stipulation also obviously arises if, instead of doing nothing, the ER actually issues a determination that you don't agree with. You have a period of 28 days from either the determination or the deemed determination within which to refer your claim forward for further analysis, for further action. And that further action, unfortunately, means that it is referred to conciliation. But if you miss that deadline, then once again, you are deemed to have accepted the determination. It's an important deadline, and it should be noted. Turning now to the RIAI contract and how it deals with delay, you will find those provisions in clause 30 of the contract. Clause 30 sets out that when, in the opinion of the architect, an event has arisen which is likely to cause a delay to the contract works or the progress of the works, then the architect may, if he deems it appropriate, grant a fair and reasonable extension of time within which the works may be completed. The clause goes further because it sets out a number of instances where the contractor will, subject to the opinion of the architect, be entitled to that extension of time. The events are listed. The events are clear. We have, having reviewed the events which are listed in clause 30, I consider that there are a couple of them which may be of assistance in dealing with this present crisis. One of them is the event of force majeure. What force majeure means is that something has happened beyond the control of either party, and the effect of the event is to either stop the works in its tracks or frustrate the contract entirely, so that neither party can comply with their contractual obligations. The important factor here is that the event is completely outside the control of either party. It's a very difficult legal argument to rely on. The other relevant issue or event is that the works have been delayed by reason of an architect's instruction. And if you look at clause 2 of the contract, there's a setting out of the kind of instructions that an architect is empowered to provide to a contractor during the course of the works. And the two relevant events are an architect's instruction to postpone any element of the works, or an architect's instruction pertaining to any other matter appertaining to the proper execution of the works. There are a couple of other provisions or events leading to delay which may be of some relevance. One is that possession of the site was not provided to the contractor in accordance with the terms of the contract. Another is that the works are delayed by reason of civil commotion, local combination of workmen, strike or lockout affecting any of the trades employed on the site. It would be a stretch in interpretation to rely exclusively on either of the last couple of clauses I've read out, but it is always worth bearing in mind that the parties to a contract can always, by agreement, change the terms of that contract. They can always reach a consensus as to what is an appropriate provision in their contract at any stage during the life of the contract. The key is that change can only take effect by agreement. Schedule 1K of the PwC contract. If you are going to seek an entitlement under clause 10.3, in other words, submit a claim for either time or money, you have to satisfy yourself and the ER that the event in respect of which you are making the claim is either a compensation event or simply a delay event. But in order to successfully claim under the terms of this contract, Schedule 1K is absolutely critical. You have to, if at all possible, shoehorn your claim into one of the events listed in Schedule 1K. Having reviewed the schedule, the events of relevance which might lead to a successful claim, or albeit nothing is clear at this stage, are event number 1, the employer's representative gives the contractor a change order. Your ability to rely on that compensation event would be contingent on the employer actually giving an instruction or direction that the works are to be carried out or not carried out in a particular way. Event number 3 is where the employer's representative directs the contract to suspend works under subclause 9.2. Clause 9.2 grants a specific entitlement to the employer acting through the employer's representative to cause a suspension of the works in their entirety. In such circumstances, Event 3 on Schedule 1K clearly demonstrates that that is a compensation event. The next event is Event 4. The contractor suspends works in accordance with subclause 12.3. That suspension will only arise under this contract, under clause 12.3, which is a provision which permits the contractor to suspend the works in circumstances where he has not been paid. That is hardly likely to be a relevant consideration under this in these present circumstances, but I just wanted to draw it to your attention in any event. Event 7 is where the employer's representative does not give to the contractor an instruction required under subclause 4.5.4 within the time required for such instruction, when the contractor has asked for the instruction in accordance with 411. That brings us back to section 4 of the contract. And Subclause 4.5.4 is an important one, and again, I'm going to read it to you. Clause 4.5.4 provides, and this is a mandatory provision. In other words, the ER has no option but to issue this direction if the circumstances arise. The employer's representative shall give an instruction that is, in the employer's representative's opinion, necessary for the completion of the works, if, in his opinion, it is physically impossible or contrary to legal requirements to complete the works in accordance with the works requirements, the employer's representative shall give a change order. The ER shall give an instruction required under this subclause 4.5.4 within the time required by subclause 4.11. That chain of clauses and subclauses is important and is relevant. If it becomes physically impossible or contrary to legal requirements to carry out the works in accordance with the works requirements, then the employer's representative is required to issue an appropriate instruction. As I speak, there is no directive from the government to close down any construction site in the country. There is no directive which requires that works cease, and there is no directive or government instruction that employer's representative issue appropriate 4.5.4 instructions to contractors. We don't know what's ahead of us, we don't know what's facing us, but it is appropriate to have regard to that clause in the event that a directive is issued by the government with regard to how sites are to operate. Turning now to the question of suspension, as mentioned under clause 9.2 of the PwC contract, the employer has a specific entitlement to cause a suspension of the works. And the employer's representative may issue that instruction at any time and apparently doesn't have to provide any reason for doing so. If such a suspension is ordered and directed, the contractor is required to secure the site. The contractor is required to take all appropriate measures to ensure that the site will be secured and will be safe during the period of suspension. Any such suspension, as we have seen, is a compensation event under Schedule 1K, Clause 3. It may be that Clause 9.2 of this contract assumes some significance in the days and weeks ahead. The RIAI form of contract does not make specific provision for an employer's right to suspend works at any time. However, it is clear from Clause 2, where it is set out that the architect may issue an instruction to postpone any element of the works at any time, that it is clearly contemplated that it is within the employer's right to cause a suspension of the works. Should such a suspension be directed by the employer under the RIAI form of contract, the contractor would have similar obligations with regard to the safety and security of the works. It's worth remembering that during any period of suspension, the contractor will remain responsible for the site, will remain responsible for the safety of the works, and will be responsible in terms of insurances for the works and the project site. So that's just worth bearing in mind. Whilst I'm in the RIAI form of contract, I'd also like to draw your attention to Clause 4 of that contract, which deals with variations arising from legislative amendments. On first review of this clause, it might appear that this would be particularly relevant in the event of further direction from the government, because it uses the words the exercise by the government of powers vested in it. Clearly, the directives and instructions coming from the government up to date in relation to this crisis arise from powers vested in the government to make such orders, to make such directions, to issue regulations. And therefore, on the face of it, it would appear that this clause might be particularly useful in assessing and analysing entitlements once all of this chaos has come to an end. I would like to just inject a note of caution in terms of reliance on that particular clause. It would appear clear that when this clause references powers vested in the government, it is powers to increase taxes, it is powers to impose levies or tariffs or license fees in respect of works and works operations. It would not appear and would certainly not have been drafted on the basis that it would be utilised for circumstances such as the ones that we are presently facing. The third limb of what I said I was going to talk about are the doctrines of force majeure, frustration, and finally, the ability to terminate one's contract. I have slightly earlier outlined the doctrine of force majeure. The words are not mentioned in the PwC contract. There's no concept in the PwC contract of the works or the project being abandoned because of circumstances entirely outside the control of both of the parties, which is the definition of a force majeure event. It is not listed as a compensation event. It is not listed as a delay event in Schedule 1K. Where it might become relevant, where it might become of significance, even with regard to the PwC contract, is where it has to be concluded that the entire purpose of the contract has been frustrated by a force majeure event. In other words, that the parties are simply incapable of carrying out their contractual obligations for reasons completely outside their control. That leads into the doctrine of frustration, which is precisely that. It has become impossible to carry out the contract objectives. It has become impossible for one or other of the parties to carry out their obligations entirely for reasons outside of their control. The PwC contract does contemplate that to a limited extent in dealing with the grounds upon which a contractor may terminate a contract. And I'd like to draw your attention to clause 12.4 of the contract, which deals with termination of the contract by the contractor. The grounds on which a contractor may terminate the contract are very limited. In the first place, it's because the contractor has not been paid and has suspended the works and has still not been paid. In those circumstances, the contractor has a contractual right to terminate the obligations. The second circumstance is where the works have been suspended by direction of the employer in accordance with clause 9.2, and that a right to terminate has arisen under that subclause. The right to terminate arises under that subclause where the suspension extends for a period in excess of 6 months. The third ground on which a contractor may terminate his contract is where the execution of the works has been suspended for a period of at least 3 months as a consequence of loss or damage that is at the employer's risk. And the fourth circumstance is that an event or circumstance outside the control of the parties makes it physically impossible or contrary to law for the contractor to fulfill its obligations under the contract for a period of at least 6 months. Whilst this contract does not use the words force majeure or frustration in describing these events, the event set out at clause 12.4, subsection 4 of the contract is precisely what I've just described as being a force majeure or frustration event sufficient to allow a termination of the contract. The words force majeure do appear in the standard form RII contract insofar as they appear in clause 30 as an event in respect of which the architect may conclude that an extension of time event has occurred and has arisen. And again, the definition of force majeure remains the same across all contracts, but the architect may conclude that the circumstances demand that either an extension of time be granted, or it can lead to determination of the contract by either party due to the frustration of its objectives. In carrying out my review of these two forms of contract, I came across a number of items of note and a number of questions that contractors might pose for themselves. Have you entered into an engagement or a consultation or some kind of process with the employer on each of the projects in which you are involved? Are you subject to notice requirements under your particular form of contract? It's relevant and important that the terms of bespoke amendments to standard form contracts be checked against the standard forms themselves. There may be particular or peculiar provisions in bespoke provisions which add or lessen the burden with regard to notice provisions, for example. Have the notices been served? Is the employer on formal contractual notice of the fact that you consider that a delay event has occurred, that a compensation event may have occurred? Have you taken, or are you planning to take, appropriate and adequate measures to protect each of the sites with which you are involved? In the event that the works are suspended, which may happen, are you in a position to move quickly to secure individual sites and make sure that the works are protected? Have you reviewed the terms of the insurances that you currently have in place? Will your contractors' all risk insurance cover any element of the loss or damage likely to arise from a protracted suspension of works on your project? Have you engaged with your broker in relation to insurance cover in respect of these particular events? Have you spoken with your subcontractors? Have you engaged with them with regard to the conduct of works and the continuity of works in respect of live sites, or the circumstances of suspension of works on any of the sites with which they are involved? Have you engaged with your suppliers? Do you know where the materials which have been ordered for your sites are actually located at present? Have you obtained clarity with regard to responsibility for off-site items and their storage? Have any off-site items vested in you or in the employer at this stage? In which case, what steps can you take in order to protect those items once they remain off-site? These are some of the issues which have occurred to us on our review of these two standard forms of contract. As stated, if you are operating under a bespoke form of contract, which contains amendments from the standard forms, it is important that you review those bespoke contracts and that you have regard to any differentiation between the relevant clauses that we have pointed out and the bespoke forms of those conditions which will appear in the schedule of amendments. If you have any queries, the Construction Industry Federation are here to deal with queries as they arise, and if we can be of assistance, please obtain our details from the CIF. Thank you.
Hello. The COVID-19 pandemic is having a significant impact on employers in terms of trying to manage their business to ensure continuity of work and also to manage absenteeism. Many workers are currently working from home. However, this may not always be an option, and other issues need to be considered, such as temporary layoff, short-time working, or indeed where workers are required medically to self-isolate, or where they may contract the virus, there are sick pay arrangements in place. We will look at a number of these options available to employers in the current situation. The recent school closures have resulted in many employees advising their employers that they're not in a position to report in to work. Other employees have advised that they're not in a position to report for work due to other caring responsibilities they may have within their own families, or indeed for health reasons. Where work is available and to ensure continuity of business, we are recommending that employers consider other options that may be available to them. These options include flexible working, perhaps working from home or from some other location. Perhaps workers could take annual leave or some other unpaid leave, such as parents' leave or parental leave. Perhaps workers and employers could agree that any days lost or time lost or hours lost could be made up at some stage in the future. Or any other arrangement that an employer and an employee can enter into to ensure continuity of business. Where workers advise that they're not available to work, and there is work available, and flexible options are not available to them, then these workers are making themselves unavailable for work and are not entitled to be paid. Where work is not available, then an employer may have no other option but to consider temporary layoff. Temporary layoff is not an unusual concept in the construction industry, and many site workers in particular have been laid off on numerous occasions during their working lives. Temporary layoff applies to a large extent to site workers such as craftspeople and general operatives. Where there are site closures as a result of completion of contracts, postponement of contracts, suspension of contracts, in other words, where the employer cannot provide the employee with work, then temporary layoff may be the only option. Regina Doherty, as Minister at the Department of Employment Affairs and Social Protection, has introduced 2 new initiatives to support workers and to ensure workers get payment in a timely manner in the event of temporary layoff. The first initiative is the Employers' Refund Scheme. The government is encouraging employers, where possible, to continue to pay employees who have been placed on temporary layoff. They are requesting employers, where possible, to pay workers a payment of €203 per week. Employers can then recover this amount from a special employers' refund scheme that has been introduced. Details of the scheme will be sent out to members and will be available for members on the CIF website. Where employers cannot continue to pay workers due to financial constraints associated with this pandemic, then a second initiative has been set up and introduced by the department. This initiative is called the Pandemic Unemployment Payment. Workers can apply for, on a very simple 1-page application form, they can apply for this payment from the department. The payment is €203 per week, and it is designed to provide workers with payment in a speedy manner. The payment will be made for 6 weeks, and within the 6-week period, workers will be expected to apply for the normal job seekers benefit in the usual way. We will now look at some of the issues associated with absence due to either self-isolation or where workers contract the virus. The Department of Employment Affairs and Social Protection has introduced a new enhanced illness benefit payment. This payment, which is €305 per week, will apply on certified advice from a GP that a worker has to self-isolate. It will also apply where a worker who is medically certified as unfit for work due to contracting the coronavirus. The payment will be made for the duration of that worker's illness. This new enhanced illness benefit will be available from day one. This is a departure from the normal procedure where workers would have to wait for 6 days or more before being entitled to an illness payment from the department. There's no qualifying criteria required. In other words, workers do not need to have a certain amount of PRSI contributions made in order to qualify. The payment of €305 per week will apply from day one. Employer organisations have agreed with government that where possible, employers will be requested to pay workers at least a payment of €305 where those workers are medically certified to self-isolate. This agreement was reached to ensure continuity of business and to ensure that workers who are medically required to self-isolate will do so and will not be concerned that the non-attendance at work will result in non-payment. It has, however, been accepted by government and the trade unions that paying workers who are required to self-isolate will not be possible in all circumstances due to the financial constraints that employers are under as a result of this pandemic. Workers in the construction industry are generally covered by the sectoral employment order for the general construction industry and the civil engineering sector. There's also a sectoral employment order in place in the mechanical engineering sector. Under these sectoral employment orders, employers and workers are legally obliged to be registered with the pension and sick pay scheme. Many electrical contractors have also their workers registered with the sick pay scheme. Where workers are either medically certified to self-isolate or where they acquire the virus, a sick pay payment of €44 per day from day 4 will be available under the sick pay scheme. This payment is in addition to the special enhanced illness benefit that is provided by the Department of Social Protection. So in summary, employers in the construction industry have a number of options in trying to manage their workforce in the current pandemic. Where work is available, employers are encouraged to consider flexible working from a remote location, agreeing with employees that they will take annual leave, or perhaps some other unpaid leave arrangements such as parents' leave or parental leave. Where work is not available, then the only option open to employers may be to place workers on temporary layoff. In such a situation, there are 2 initiatives introduced by the department. One is the Employers Refund Scheme. Details of the scheme will be sent out to members and will be made available on our website. The other initiative is the pandemic unemployment payment, which will be made in a speedy way to workers who have been placed on temporary layoff as a result of the pandemic. Where workers contract the virus or are ill or are required to self-isolate, then there are 2 payments available. One is the enhanced illness benefit from the department, which is €305 per week. And the second is the sick pay scheme, which is administered by the Construction Workers Pension Scheme. This is a payment of €44 per day from day 4 to day 50. It's important to note that the initiatives introduced by the Department of Employment Affairs and Social Protection in terms of workers on temporary layoff or workers who are either self-isolating or who contract the virus, that these initiatives are available to employees and the self-employed. Details on all of these schemes and the options available to members in terms of managing their workforce in the current pandemic are available on the CIF's website. Alternatively, we would request that members contact us at the Industrial Relations Department and we can talk you through all the various options that are available. Our information details, including our email addresses and our phone numbers, are available on the CIF website. Thank you.
My name is Dermot Carey. I'm Director of Safety and Training at the Construction Industry Federation. COVID-19 is an emerging hazard that we're all beginning to learn how to manage. The CIF is working with its members and supply chain in order to ensure that they continue to work, but do so safely. The core safety message are as per the HSE public health advice. That's good hygiene and regular hand washing, cover your mouth and face when sneezing or coughing, avoid touching your face, clean and disinfect areas that you've touched, and of course, social distancing. CIF is adding advice to its website on a daily basis. That's www.cif.ie. A major benefit of the construction industry is that it has a long tradition of sharing information in relation to health and safety. This is particularly relevant now, and we'd welcome any strategies that members have developed that are working for them that we may share with the construction community. So please send any advice that you have to dcarey@cif.ie and we will prepare advice that we will circulate to the construction community. Also, remember to visit our site on a daily basis. As I said, that's www.cif.ie. Thank you and keep safe.
Hi, Tom Parlin here. This webinar that we're putting together today to bring our members and I suppose the general public up to date on the implications for COVID-19 to all of us in the construction industry and to all of us who work. Clearly, a lot of the emphasis is on contractual obligations, and COVID-19 may well have substantial impact on individual companies' contractual obligations, both privately and in public contracts. And we have expertise in that area, and we'll be making that available to you. We have made that available to you. The other issues, I suppose, around the whole issue, clearly it's an unprecedented crisis and a situation that I certainly never envisaged. The implications for the country and for the health of all of the citizens, the implications for the economy, very, very substantial. But my responsibility as Director General of the Construction Industry Federation is to make sure that my team supports our members insofar as ever we can, keeps them up to date, and so on with developments. So we've been in quite regular contact with the government. We've had a number of meetings in the past with the Chief Medical Officer, Tony Houlihan. Find them absolutely superb. And clearly our interests now are to continue to keep the doors of industry open, to keep the sites open, to collectively work with everyone to make sure that sites are safe, compliant places for people to work, that we're neither putting our workers at any risk for themselves individually or putting the rest of the population at risk with regard to any further spread of the virus. We've come up with very, very good operational procedures that, insofar as we can on site, respects social distancing in terms of all the hygiene issues and so on, and generally how workers behave themselves on site. Like, after all, construction sites largely are outdoor facilities. People wear protective clothing to a large extent. And I think now people are very, very conscious of the risks that there might be exposing themselves to. So I think we have a very, very good procedure in place. We think, and our members think, it's important that the industry keeps its doors open. We're a very, very important part of the economy. We're employing over 150,000 people. We're providing, in a lot of cases at the moment, emergency facilities for the HSE that will be required for future treatment of this disease. But otherwise, we're completing hospitals, one major one that will be finished in the next couple of weeks. We're completing houses, we're completing facilities for the pharma industry that may well be centrally involved in the production of product that may eventually come to terms with the whole virus that we have. So my message very much is to the members out there: follow the guidelines that are laid out rigidly in terms of hygiene, in terms of procedures. I know that individual companies have put in extra procedures. CIF will be centralizing those and circulating them to everyone. Let's keep the industry going. Let's keep people employed safely out there, and let's look forward to us getting over this crisis. We're proactively working with the whole supply chain. I've been in regular contact with the builder suppliers, with the Concrete Federation, and they are putting very, very substantial procedures in place to keep their supplies open, and they guarantee me that there is no shortage of any product. Likewise, we're working very, very closely that all our projects will proceed, that we will keep the balance between keeping people safe and keeping the industry open. And I'm very determined that that will continue, and I'm very confident that we can proceed in a very safe manner.